Mr. Spies, you may proceed.
Good morning, Mr. Chief Justice, members of the court. May it please the court and counsel. I'm honored to be here this morning to speak on behalf of Bruce Willey, Cedar Rapids lawyer who admittedly violated the model rules, the rules governing conflicts of interest, obtaining informed consent from two valued clients and friends. We're here to appeal the recommendation of the Grievance Commission recommending that this court impose a 30-day suspension of Mr. Willey. The facts of the case admitted in the stipulation submitted to the commission and agreed to by Mr. Willey demonstrate that he played a role as an intermediary between two valued business clients. One, Dave Wild, who Mr. Willey had a long-standing business relationship with as an attorney, advising him on business affairs, incorporation, tax returns, and so forth. And another client, Henry Winowitz, who also was a client in business matters and tax matters. In 2006, Mr. Willey, who had a broad practice in Cedar Rapids, Iowa, not only as a lawyer but also as a CPA, incorporated a company called Synergy Projects, Inc. on behalf of Dave Wild. He'd also done some other business planning and incorporation work for Mr. Wild in the past. In 2010, Mr. Winowitz, who was engaged in investment opportunities and business planning with Mr. Willey, was informed by Bruce Willey that another client had an investment opportunity involving a structure that I'm not very familiar with. It involved hedge funds, banks, overseas investment platforms, and the opportunity was this presented to Mr. Winowitz. If he were to invest $100,000 in this trading platform overseas, that in a very, very short period of time, he would be not only repaid his initial $100,000 investment, but in the course of about 3 months, he would get another $100,000 on top of that, and then still another $100,000 on top of that. Mr. Willey's role in this transaction was to prepare a promissory note which memorialized this agreement. Promissory note was given to Dave Wild. Dave Wild signed it both on behalf of his position as an officer in Synergy Projects, Inc., but also signed it individually. The note was then given to Mr. Winowitz. The investment was accomplished. $100,000 was paid to Mr. Willey's trust account. From the trust account, it immediately went to Synergy Projects, Inc. Now, notably, over the course of the next several months, in fact, over the course of almost 2 years, Bruce Willey played really no visible role at all other than to convey to Trey Winowitz information he was receiving from Dave Wild about the progress or lack of progress of this investment. On virtually a weekly basis in July and August of 2010, all the way through the fall of 2010 into 2011, on as much as a weekly basis and almost on a monthly basis, Mr. Willey was informing Winowitz what was happening with the Wild investment, or the lack of that investment. In fact, as late as December of 2011, Bruce Willey was encouraging Trey Winowitz to talk directly with Dave Wild about what was happening with the investment. There was no concealment of any information, and I think it's undisputed both in the record and in the stipulation that Mr. Willey made no representations, certainly no misrepresentations about what was going on with this money. The admitted violations are very clear. Mr. Willey should have obtained written informed consent from both of these clients, making it crystal clear that he was dealing with two clients. He should have obtained consent to proceed as counsel for both if he was going to proceed as counsel for both. He should have done it in writing. Everything should have been completely transparent. Now, I think it's very important for the court to bear in mind, as the commission did, that he was dealing with two sophisticated business people. And the commission found in particular that Trey Winowitz's sophistication as a professional investment counselor, an experienced professional who had also touted his own experience advising or being involved with the FBI, the IRS, and the Justice Department in fraud investigations, that his sophistication was, in essence, a mitigating factor in their consideration of the discipline that should be imposed and recommended to this court.
Well, let me just ask a general question and share with you what's bothered me about this case. As a general matter, the idea of business transactions involving multiple clients is troublesome. I mean, I understand you can paper it and you can get informed consent, and there might have been a way in this case to structure it appropriately. But the overall message to the bar is one of the things that we consider. And the notion of these types of transactions troubles me. It troubles me because they're fraught with problems indeed, as you wouldn't be here if they weren't. So address kind of what I'll characterize as my general concern. My general concern is this is a troublesome area of law, and we need to make a clear statement about it. I mean, that's why a suspension might be justified in this case.
Are you concerned about Mr. Willey's involvement in this, or the nature of the transaction?
The nature of the transaction, really, I think.
Yeah, you know, it's really a mongrel, and it's difficult to find any cases that are similar at all to this. It was conceived as an investment, but structured as a loan. And surely a diligent lawyer doing due diligence would have said, you know, there's something peculiar about this. There's no collateral, and you're dealing with people overseas. You're dealing with hedge funds. You're dealing with banks. You're dealing with foreign governments. And yeah, there were all sorts of trademarks in this case, of this investment, that made it look really, really peculiar.
Well, here's you say there's no analogy. I mean, when I was reading the file on this case, it struck me as similar to the Wright case that we dealt with a few years ago involving the Nigerian money scam.
Yeah, the pie in the sky case.
Right, which, I mean, I look at this thing and I have to say I can't believe that Mr. Winowitz wanted to have anything to do with it if he had any sophistication at all. But the problem is when you put a lawyer in the middle of it, maybe that adds a veneer of respectability to it, and that's why we have this rule about simultaneous clients and not representing both sides of the deal. That's my concern. Is that fair?
There's no question that is a matter of concern, but I think that what makes this unique is Mr. Winowitz's sophistication as an investor. Not only was he sophisticated in investing, but also...
I guess I just, in looking through the file and looking through all this, I don't see the degree of sophistication that you may want to state attributed to him. You know, he can say he deals with the IRS and that. He deals with retirees in handling their investments for retirees. And, according to his resume, he received his bachelor's degree in finance from LSU in 2001. And he's got, it's all in the record, it shows this. This doesn't, to me, lend me to believe that this is a sophisticated investor like you want to say, that he's used to dealing with international, you described it better than I can right here, but that he's dealing with international markets and bonds and sale of bonds and junk bonds and currency exchanges and Hong Kong banks. I mean, this is not, I can't look around the room and see anybody that would think that was a good investment.
Well, there's no question, as I said, it was a mongrel. What's important, though, is at the very last page...
But I just want to be clear that I don't really buy into this, that he thought that this was a sophisticated international bond trader who can invest $100,000, and then when you get through the record, and he hasn't been paid anything, of course, in 4 months, and he should have been almost paid $400,000 in 5 or 6 months, then his wife's getting on him, it's like, where's our money? We need this money to buy a house in Florida or something. This is not a sophisticated person that just has $100,000 sitting around, and that's what's really, really bothersome to me.
Here's the only thing I can say in response to that. At the very outset of the investment and Mr. Winowitz's involvement in this investment, he was furnished with a schedule about how this investment was supposed to work. And that was done before there was any promissory note signed, before there was any money exchanged. And also in the emails between Mr. Winowitz and Mr. Willey, it says in there that the subject of risk was discussed.
But it also says that it's really no risk. He makes a representation, he actually does make a representation to Mr. Winowitz that this is really no risk.
And, you know, and I think that the record is clear that he was relying on the information, Bruce Willey was relying on the information he was getting from Dave Wild about this.
Well, and I don't care about that. I mean, I'm talking about the representation from Mr. Willey back to his other client saying, well, this is a safe investment, and by the end of the year, you're gonna have $400,000 for your $100,000 investment.
It was negligent for him to make that representation based on what he knew and based only on the representations that he was getting from another client. No question about that. And I think also his role not only as a lawyer but as a CPA blurred the distinctions even more. But there are a lot of mitigating factors here, and I encourage the court to consider them, and most notably, Mr. Willey's unblemished record as a professional. He has served his community, he has served his church, he's served his school with distinction. He has lost not only two valued clients, but two valued friends. He was blinded, I think, by his interest in trying to cultivate a winning investment on behalf of both clients, and there's no question that he violated the rules. But a reprimand will do the business.
Thank you, Mr. Spies. Ms. Robinson.
Good morning. May it please the court, counsel. My name is Amanda Robinson, and I'm Assistant Ethics Counsel for the Attorney Disciplinary Board. The Grievance Commission's recommendation of a 30-day suspension in this case is fair and reasonable based on the facts presented and the evidence presented in this case, and also based on prior case precedent. This court should follow the Grievance Commission's recommendation and impose at least the 30-day suggested suspension. The facts in this case really aren't in dispute.
Before you go any further, your brief suggests that we should go up to 4 months. What's the basis for going up to 4 months?
The basis of going up to 4 months is some of the case law that the board cited and some of the aggravating factors involved, particularly the persuasive case out of Oregon. You know, and I think Mr. Spies kind of hit the nail on the head. This is very difficult to find a case exactly on point with this kind of strange fact pattern. The closest I could find was that Oregon case where you've got a lawyer who was representing two parties to a loan transaction. There was a little bit of, I think maybe more direct benefit to the lawyer in that case than there was here, although I think certainly it can be argued that there was indirect benefit to Mr. Willey as a result of
This case a lot different from Qualley. I mean, those people were self-deal. Those two fellows were, they had a hidden interest in the deal that they were recommending to their client. There's no indication that Mr. Willey got anything out of this deal, right?
I think it is different because of the more apparent self-dealing that is involved in Qualley. I don't think you can say that there was absolutely no self-interest. Now, obviously, the board didn't specifically charge the self-interest as a separate count, as a separate rule violation, because it was very difficult to quantify the benefit that Mr. Willey did receive as a result of this. But you've got a situation where he's got a longtime friend in Mr. Wild, a longtime business associate, and it was stipulated they are business partners in other entities. And so, you know, just generally, you know, common sense tells us that if my friend and my business partner is doing well financially, that in a roundabout way is probably going to benefit me as well. And I think that that should be considered an aggravating factor in this case. Even though it's not direct self-dealing, it is certainly indirect self-dealing.
Let me just, I want you to correct me if I'm wrong, because the records do disclose, was Mr. Willey then also during this period of time from 2010 to, let's say, 2015, when I think the relationship with Mr. Wild ended, he was continuing to do substantial legal work for Mr. Wild, wasn't he? And-
Yes.
And doing legal work for him during all this time as well, and collecting fees.
Yes, and there's billing records included in the record that confirm that. So yes, there's an ongoing business relationship there. I think the billing records indicate at least $40,000 in legal billings between Mr. Wild and Mr. Willey, which, you know, is a pretty substantial business relationship. And that doesn't take into account, what we don't have in the record is, you know, what kind of financial advantage did Mr. Willey have from the actual business partnerships that we know existed, but we don't have as much detail on.
Is a reprimand sufficient in this case, particularly in light of Mr. Willey's unblemished record and his community service, his lack of financial gain here? Is a reprimand sufficient to remind lawyers to, hey, get the written consent in writing if you're putting a deal together for two concurrent clients?
If there were no harm involved, I would say yes. One of the things that we discuss quite a bit in the board's brief is the American Bar Association model standards on sanctioning lawyers. And those standards, you know, obviously are simply persuasive at this point here in Iowa, but I think they're instructive in that they really present a fairly bright line rule in situations where you've got a conflict of interest that doesn't involve quantifiable harm to a client versus cases that involve conflicts of interest that do involve quantifiable harm to the client. And obviously in this case, we have some pretty extensive quantifiable harm to the client, and a very, frankly, blatant and obvious conflict that it seems quite apparent that Mr. Willey, particularly based on the fact that he'd recognized similar conflicts in the past, that's in the record, he knew there was a conflict. There's no way he couldn't have known there was a conflict.
Is the $100,000 loss, though, can we blame that on the lack of disclosure, or is that just an investment risk the investor chose to take on? I mean, how do you connect that with the attorney's ethical breach?
I think the connection to the attorney's ethical breach comes into play in that, in regard to the lack of security involved in that loan transaction. I think, you know, you've got this client who, I think Justice Zager hit the nail on the head. You know, the other party would like to say that this is a super sophisticated client.
It was an obviously unsecured thing. I mean, I'm not a sophisticated investor, and that's apparent from day one. And certainly, I can't believe Mr. Wienowitz would have been not aware that it was an unsecured investment.
I honestly don't know that he did. And I think that tells you the level of sophistication that was going on there.
Well,
there's no evidence that there was any discussion regarding that specific point.
Okay, but the problem I'm having here is following up on what Justice Mansfield just asked. I mean, although he may not have been a hedge fund expert and an international financier, he was sophisticated in terms of knowing the fundamentals, and he knew, looking at the interest rate alone, the return on the investment had to raise all kinds of red flags, did it not?
One would think. I certainly wouldn't have done this. But I think that Justice Mansfield in his questioning earlier...
The reason I asked that is following up on Justice Waterman's question about the causal connection between Mr. Willey's conduct and the fact that the investment occurred. I mean... What I think the important point to remember is this left Mr. Wienowitz with very limited means of recourse if this deal goes south. And like we all probably would have anticipated, if we'd have been in those shoes, the deal went south. And Mr. Wienowitz has not been able to recoup any of his losses because of the way this deal was structured
In the
and
record?
who structured it.
Is that in the record? I mean, he may have a malpractice claim against the lawyer. Has he filed one? Is that in the record? Do we know?
That is not in the record,
Then
no.
how do we know that he has no other recourse?
I think it is in the record that he has not recovered any of the funds. So I guess that is the fact that I'm relying on in making those statements.
Well, let me just see if I can pull it together in my own mind anyway. you know, the causation, when we talk about the causation aspect of things, at least if you have a written disclosure, you're telling one client that you're dealing with another client, which I think it's not as black and white as it may have been presented, that Winowitz even knew he was dealing with another client of Willey's, because there's just a difference of opinion. You know, Winowitz says he never was advised that he was dealing with another of Willey's client. He just thought it was a blind investment in something else. And he never said, he says he never was advised that it was another client. So all the causation is, all these disclosures say, number one, you're my client, you're dealing with my other client.
Right.
Number two, you need to seek legal counsel. But we have nothing there. If we would have had that and he still did it, you know, obviously we wouldn't even be here.
Right.
But that's, to me, the causative factor of why there's a problem here with the attorney not getting the consent and waiver and doing all the things he's supposed to do with a concurrent conflict of interest between two clients.
Right, and not only did he fail to disclose that Mr. Wild was a client, he failed to disclose the extent of the relationship, which I think is a pretty big failure. You know, we've got, I think in Mr. Willey's personal statement attached to the stipulation, he talks about his longtime friendship with Mr. Wild. You know, if he'd have disclosed that, if he had disclosed his outside business partnerships with Mr. Winowitz, I think Mr. Winowitz would have taken a closer look at this and perhaps, you know, prevented the situation from happening altogether. And I want to reiterate, too, you know, something that I think Justice Mansfield touched on earlier in the questioning with Mr. Spies was, you know, the fact that there was a lawyer involved kind of does give this, I think you called it a veneer of respectability. And I think, you know, when you look at the materials submitted by Mr. Winowitz in his initial complaint and the other documentation and evidence in this case, you know, this money went through Mr. Willey's trust account. He's dealing with a lawyer who has helped him with, you know, tax issues and so on and so forth. And he says in the emails that Justice Zager was citing, you know, I'm trusting your judgment on this. That's what Mr. Winowitz said to Mr. Willey. And he was basing that statement on Mr. Willey's email that said there really is no risk involved in this transaction. If this is a sophisticated client, why is Mr. Willey having to do so much assurance that there's no risk involved? I mean, those two things just don't jive. And so, you know, I do think that the failures to make the appropriate disclosures, the failure to advise, to seek independent counsel certainly contributed to the harm in this case. The other thing, I see that I'm over time, but I want to mention just briefly, I think the thing we also have to keep in the back of our minds as we review this case, you know, we've had a mention of, you know, what message is this going to send to the bar? You know, what warning do we need to send to the bar? The other thing I think we need to keep in mind is public perception in this case. It's going to look really bad if we fail to impose a suspension in a case like this where, you know, $100,000 goes missing and a lawyer is involved and a lawyer is involved and the harm really was caused because of these failures to make these disclosures. I think that's something that should be kept in mind. At a minimum, the board is asking for this court to uphold the 30-day suspension, and as we've presented in our brief, we think that there is significant precedent for even lengthier suspension as well. Thank you.
Thank you as well, Ms. Robinson. Mr. Spies, you may present your rebuttal.
You know, the notion of risk is something that's difficult to grapple with here, and these are waters that I don't swim in. So we have a record here of two sophisticated businessmen, sophisticated on some level, sufficient to persuade one sophisticated businessman to invest $100,000 in a deal about which we know very little, other than the fact that there were representations made. And the representation made by Mr. Willey, as shown in the initial email on July 2nd, 2010, to Trey, attached to the timeline for the opportunity per our conversation. I spoke with Dave and he indicates that the bank and hedge fund have already approved the instrument, so there isn't really risk related to that, though that is an item we discussed. Please let me know the questions that you may have, and I hope you are able to take advantage of this opportunity. And beyond that, there really weren't any representations other than this is
I thought
what.
there was another email, and maybe I'll have to go back and look at it as well and see that wasn't in conjunction with that, but,
Yeah, and the point is that there was risk, it was discussed, and people went into this with eyes kind of half open. And I'm sure that Mr. Winowitz was banking on having a great return on this amazing investment. And just as greed motivates business people to do things that they probably wouldn't ordinarily do, it factored in here.
How do you answer the harm to the client argument? Because I do know the ABA standards differentiate between reprimand and suspension based upon harm to client.
Yeah, and it's an interesting notion here is whether the harm, the $100,000 loss, was the result of Mr. Willey's failure to disclose that this investment was with a fellow client, even though he believes that he did inform him.
But don't you think that if Mr. Willey got another attorney to represent him in this transaction, you think he'd really go through with this deal? No security, you're gonna get 3 times your money in so many days. I mean, I'm gonna put you on the spot. Would you tell him to enter in that transaction even though you're not sophisticated investor, you tell us?
Yes, I mean, this has all the hallmarks of a very unusual investment. And
That's what he was robbed of, the right to have independent counsel tell him whether it was a good deal or not. I mean, that's the violation. Now, and the question I guess I have is, if he had that independent counsel, would he be so quick to jump in that transaction knowing these things?
well, we don't know, and we can't know that. And it may be that there was reassurance here, knowing if Mr. Winowitz had known that he was dealing with another one of Bruce Willey's clients, he would have been even more reassured that this was a good investment. We can't know. We don't know.
That's the whole purpose of the rule, is so someone gets independent advice. And you look at the Wright case, you know, the Wright case is sort of similar, but not similar, but it's the same type of thing. You know, the attorney thought it was a great deal and started getting his clients involved in it.
Yeah, but unlike, investment with Nigerian royalty, you couldn't go on the internet and say, what's wrong with this investment other than the fact that the terms look just too good to be true. And so for that reason, we think that a reprimand is appropriate. And importantly, Mr. Willey had no financial interest in this. He was not an investor in Synergy projects. He incorporated it. He was a registered agent. Beyond that, he had no financial stake in this
But he
whatsoever.
did have a client who he wanted to continue a relationship, which he did for 5 years. I mean, that is some interest in the thing.
You know, but that pervades every lawyer-client relationship. You always want to cultivate a good relationship with a client, be they a criminal defendant, a businessman, a businesswoman. You always want to cultivate.
That's another reason for the rule, to prevent you from using your cultivating of a client to take advantage of another client. I mean, that's one of the reasons for the rule, if you look behind it.
No question about it, but we don't know, because the record doesn't bear out, that a written disclosure of you're dealing with another one of my clients would have made any difference in the course of this, whether it resulted in a loss or not resulted in a loss, resulted in an investment, not resulted in an investment. There are plenty of indications here that Mr. Willey certainly has been sadder and wiser because of this. A reprimand is going to scourge him professionally. Every time another lawyer sees him walking down the street, he'll know that Bruce Willey screwed up. A reprimand is sufficient and no greater than necessary to meet the requirements of lawyer discipline cases, both for the public, the bar, and Mr. Willey.
Thank you, Mr. Spies, and Ms. Robinson, thank you again. The Willey case is now submitted.